The D.C. Circuit Court of Appeals may not even have jurisdiction to hear Donald Trump's appeal on the issue of absolute presidential immunity, and they may be forced to just dismiss the appeal and send it back to the district court so it can proceed to trial. So says an organization called American Oversight that filed an amicus brief with the D.C. Circuit Court of Appeals, which cited a case from 1989, which is actually very persuasive as to why the D.C. Circuit Court of Appeals does not have jurisdiction to hear Donald Trump's appeal on the issue of absolute presidential immunity. So this group, American Oversight, represented by two of the top law firms in the country, Arnold and Porter and Kay Scholler, filed this amicus brief, or the Latin term is amicus curiae, which means friend of the court brief. These are briefs, we talked about it here on the MeidasTouch network before, briefs that are submitted by third-party outside entities, parties who are not parties to the case, who are trying to persuade the court to take certain action. The courts are not required to accept the amicus briefs. They're not required to read the amicus briefs. They're not binding because, of course, these are outside entities submitting it. You could file an amicus brief. I could file an amicus brief. But normally the court's going to only hear amicus briefs from influential groups, and usually only if, they'll read things if there's certain law that may be missing, or to hear other kind of outside perspectives. And here, this group, American Oversight's telling the D.C. Circuit Court of Appeals, look, we think that federal judge Tanya Chutkan, Jack Smith, and you, the D.C. Circuit Court of Appeals, may be missing a key jurisdictional issue. And so they argue in this brief, the American Oversight Organization argues, starting on page 4, that there is a Supreme Court case authored by the late Justice Scalia, a former conservative Supreme Court justice who passed a little bit ago, called Midland Asphalt Corp. Versus United States. It's a 1989 case, and it explains the collateral order rule and when interlocutory appeals can be made to the various courts of appeals from a district court's order. The normal rule is you have to wait until a final judgment. In the case of a criminal case, a conviction, and then the criminal defendant, post-conviction, can bring an appeal regarding a final judgment or as to the entire case. The idea is you don't want, in criminal cases or even civil cases, but we're talking in the criminal context here, you don't want kind of piecemeal appeals that tactically delay the case, or that every time the district court judge gives an adverse order to the criminal defendant, if you can keep on appealing every order to the D.C. Circuit Court of Appeals or to the respective Court of Appeals, it will take forever and it will be kind of tactical delay. So the collateral order rule is the exception to the final judgment rule, which says that in very rare circumstances, you can take what's called an interlocutory appeal, meaning in the middle of the case when there is some order that takes place that satisfies certain characteristics such that it's viewed as a collateral order and satisfies the collateral order rule, where you can take an interlocutory appeal, or basically a direct appeal, before there's a final judgment and conviction. And by the way, that's exactly what Donald Trump is invoking by going to the D.C. Circuit Court of Appeals, right? In the middle of the Washington, D.C. federal criminal case, as it was proceeding, Donald Trump brought a motion to dismiss the indictment against him that was unsealed in August by Special Counsel Jack Smith. Donald Trump filed a motion to dismiss on the grounds of absolute presidential immunity. That was rejected. It was denied by federal judge Tanya Chutkan. And then Donald Trump took an interlocutory appeal, viewing that order by Judge Tanya Chutkan as a collateral order. Donald Trump took this interlocutory appeal, an appeal kind of in the middle of the case, saying that's a collateral order. Now, D.C. Circuit Court of Appeals, you need to rule right now. And that's on that basis, Judge Tanya Chutkan stayed or paused the district court case while the D.C. Circuit Court of Appeals hears all of this. So what American Oversight is arguing is no. You don't have jurisdiction, D.C. Circuit Court of Appeals, based on the Midland Asphalt Corp. v. United States case decided in 1989. that addressed the issue of collateral orders. And Justice Scalia, writing for the court, said that there has to be, because Scalia viewed himself as a strict textualist, there has to be some text in the United States Constitution or in a law or in a special statute that basically authorizes the interlocutory appeal that would create some affirmative right to this interlocutory appeal and deem what the district court does a collateral order. So there has to be some text. It could be in the Constitution. It could be in a statute or a law. And what this organization, American Oversight, argues is the issue of absolute presidential immunity is not found in the text of the Constitution. There's no statute or positive law or any type of law that references absolute presidential immunity. Donald Trump is trying to create some negative inference based on the impeachment clause that the only way for there to be punishment against a former president or executive or president would be through the impeachment clause. And if you're not convicted in the Senate, that serves to prevent any charges from ever being brought. That's Trump's kind of contorted argument, but what American Oversight says, there's no text that says that. And if we're strict textualists, and Scalia had a strict textualist decision in Midland Asphalt Corp versus United States, this 1989 case, appealing on absolute presidential immunity is not a collateral order. You can't take an interlocutory appeal. So American Oversight's organization says, on that basis, D.C. Circuit Court of Appeals, you shouldn't be able, don't even get to the merits. You shouldn't be allowed to hear this case. Dismiss it. Send it right back to Judge Tanya Chutkan and let it go to trial. You don't need to get to the merits of the issue. The merits, of course, is what Judge Tanya Chutkan found, that there is no absolute presidential immunity for former presidents in criminal cases based upon the text, structure, and history of the United States Constitution. You also don't have to get to the analysis even in Blassingame, which is another way that you'd basically say why Donald Trump doesn't have absolute presidential immunity. Blassingame's that other D.C. Circuit Court of Appeals case, which said that Trump's conduct relating to the insurrection constitutes election campaigning activity, which under the 10th Amendment, that's stuff that's reserved for the states, or otherwise elections are states' rights issues under the 10th Amendment, or otherwise for Congress, but has nothing to do with the Article 2 powers of the executive. So you don't even have to get to those issues Judge Chutkan got to, or that the D.C. Circuit got to in Blassingame, D.C. Circuit Court of Appeals, because you don't have jurisdiction. Judge Chutkan's order isn't a collateral order. Trump shouldn't have the ability to do an interlocutory appeal right, interlocutory appeal. So here's the main argument, and it's powerful. The logic is very simple. It's well written. You got some top law firms putting this thing together. When I read it, I was like, that's brilliant. I mean, Jack Smith, Judge Chutkan, D.C. Circuit Court of Appeals, no one thought of this yet. It seems so simple. It says the court should dismiss this appeal for lack of jurisdiction. Under controlling Supreme Court precedent, an interlocutory order denying immunity in a criminal case is not immediately appealable unless the claimed immunity rests upon an explicit statutory or constitutional guarantee that trial will not occur. It's Midland Asphalt, strict textualist. Is there anything that mentions the absolute presidential immunity in the Constitution or in a statute? No. Okay, so D.C. Circuit, you can't hear this until there's a conviction. You can't hear this until the end of the case. You can't do it on an interlocutory appeal. It goes on to say, the Supreme Court has identified only two constitutional guarantees against trial that satisfy this demanding standard: the double jeopardy clause and the speech or debate clause. Applying Midland Asphalt, this court and other courts of appeals have long dismissed interlocutory appeals asserting claims of criminal immunity not based on explicit textual guarantee against trial, including judicial immunity, transactional immunity, and immunity rooted in structural separation of power principles. The argument asserted by Donald Trump here fails the Midland Asphalt's straightforward rule of appellate jurisdiction, and obviously so. On their face, Trump's arguments do not rest upon any explicit constitutional guarantee against trial. Instead, he asserts immunity under structural constitutional principles and an unstated negative implication of the impeachment judgment clause. Because neither claim rests upon an explicit guarantee that trial will not occur, the court lacks appellate jurisdiction. The court should dismiss this appeal immediately and remand for trial without further delay. It goes on to talk about how this was a decision that was ultimately reached by Justice Scalia. It talks about how Midland Asphalt has never been overruled, and the courts of appeals have read it to mean exactly what it says. Interlocutory appeals in criminal cases are limited to those rights not to be tried that are explicitly set forth in statute or the Constitution. The test is not whether the right alleged to be impaired is grounded in the Constitution. The test is whether the pertinent protection, constitutional or statutory, explicitly guarantees a right to be tried. In other words, is there specific text that mentions those words, absolute presidential immunity? In other words, only when a statutory or constitutional provision itself contains a guarantee that a trial will not occur may courts of appeals intervene prior to a final judgment to review the defendant's claimed right not to be tried. What I love about this, too, is that they're not only citing what Justice Scalia, kind of right-wing stalwart, late great conservative judge, if you're in the strict textualist movement, I don't think Scalia is that great, but if you're the conservative movement, that's what you would, think if you're a strict textualist. But look, they also cite Justice Gorsuch when Gorsuch was a Circuit Court of Appeal judge for the 10th Circuit. Judge Gorsuch agreed with this as well. So they're saying, look, when you were a Circuit Court of Appeals judge, you also agreed with the Midland Asphalt doctrine that Justice Scalia set forth. And so this is not a collateral order, and D.C. Circuit, you don't have jurisdiction. Now, this is an objective show, so let me give you what I think Trump's argument could be in response to that. Aha, you say that double jeopardy is an issue that even under the Midland Asphalt doctrine that has been recognized as one of those limited circumstances where you can take a collateral order. One of the reasons why Donald Trump has tried to cast his absolute presidential immunity argument as a double jeopardy issue by arguing that the impeachment judgment clause, when he was not convicted by the Senate regarding the January 6th insurrection, when he was not impeached by the Senate, Trump is arguing frivolously that double jeopardy attached. In other words, that he can't be tried again for the same crime that he was not convicted of by the Senate. So Trump's trying to, is what his lawyer is trying to do, trying to say, yes, perhaps Midland Asphalt will say if it was just absolute presidential immunity, but what Trump's going to claim is, well, I'm actually arguing absolute presidential immunity based on the impeachment judgment clause creates a double jeopardy issue where you can try me twice because I wasn't convicted by the Senate, even though I was impeached by the House of Representatives. So that's what he'll argue in response. But this jurisdictional argument, I think, is a good one. Was not raised by Jack Smith or Judge Tanya Chutkan. Perhaps they didn't raise it because of that double jeopardy issue that I just described to you. But that's what will be argued. So I think that adds another interesting wrinkle to this analysis. And I thought they did a good job identifying an issue that has yet to be identified yet. And I wanted to share with you double jeopardy, collateral order, interlocutory appeal. You see the layers of complexity in an issue that's kind of obvious, that Donald Trump should not have absolute presidential immunity because we don't have kings or authoritarians in our democracy. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. Thanks to your support. Have a good one.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.